Counsel, before we kind of get started, you represent,
I represent the biological father, Nathaniel Johnson.
and you represent the mother. Mother. Over here.
We represent the LA's David and Terry case, and they're the custodians of Azalea and Daniel, which is the next case on the docket, Your Honor.
All right. Have you all divided the time at all?
Yes, Your Honor, I think I'll need just 5 minutes and he will have the remainder.
Okay, and you'll reserve time for rebuttal?
Yes.
Okay, but that'll come out of your
Out of
10 minutes.
his, yes,
Okay.
Your Honor.
So you'll have 5, 10 minutes, and when you come up, you can tell us what you'll say for rebuttal. What about over here? More than one argument?
No, Your Honor, we just have, well, the full 15 minutes should be sufficient, Your Honor.
All right, that'll be fine. Okay. Now, thank you. Proceed.
If it may please the court, my name's Glenna Overton Clark of the Knoxville Bar. I represent Nathaniel Johnson, the biological father. In this case, I would like the court to consider that the allegations or the actions of the mother are separate from the father. In this case, as I've read the transcript, I was not in the trial court on this. I was court appointed for the appeal. The issue is whether or not it's clear and convincing evidence as to whether or not the father interacted or abandoned the child. In this case, the father attended 2 therapy sessions with the child, and then Anderson County Juvenile Court halted those sessions until he had a hair follicle sample taken. He submitted a hair follicle sample, and then the pandemic hit. The lab shut down. Everything stopped. We don't know what happened to the results of those, so he could not continue with his visitation because the results from the hair follicle test never came forward.
Was there any proof that the father ever called them, tried to follow up what the status of the hair follicle test was?
From the way that I read the transcript, no, Your Honor. The father, I believe, testified that he was waiting for the results. He was waiting to hear something from juvenile court, and the next thing he knows is he receives a petition to terminate his parental rights.
Okay.
The appellees did not present any evidence as to the fact that he had failed a hair follicle sample. They just proceeded on. I think in the way I read the transcript, they focused more on the mother's actions. They didn't focus on the father. The father was not living with the mother at the time the child was removed from the home. So we contend that at this point that there was no clear and convincing evidence that the father had abandoned the child. They did raise the allegation of financial support, but they withdrew that at the trial. The second issue is whether or not it was in the child's best interest, or is it in the child's best interest to terminate the father's rights. The therapist said during the 2 family therapy sessions that the father acted appropriately, safe and appropriate conduct with the child. The father testified that it was all good. There were hugs and kisses during those therapy sessions. The therapist also testified that after the second therapy session, she would have recommended reunification with the father. So I believe that there was no proof that the father was not a good and loving father, and that there was no proof submitted as to whether or not it was in the best interest. I think that is something that should be determined. In this case, as we all know, everything should be by clear and convincing evidence. I believe in reading the trial court transcript that what happened is that the court focused on the mother, and the court just lumped the 2 parties together and found that it would be in the best interest to terminate the parental rights of both. But I contend that at the trial court there was insufficient evidence. Clear and convincing evidence was insufficient to support the theory that, or the order that the father's parental rights should be terminated.
Thank you. Counsel.
Thank you, Your Honor. May it please the court, Andrew Beamore, Knox County Bar. I was the trial attorney for the mother at the trial, although I did take over for counsel.
You want to reserve any time for
Yes,
both?
Your Honor, I apologize. I would reserve 3 minutes.
How many?
3 minutes.
3 minutes. Okay, go ahead.
I apologize. I did take over for counsel at the end, right before the trial began. I took over in May, and then I believe we began the trial in June. The problems I see, and I put in my brief, I contend are major problems, such as allowing the CASA brief into the evidence. That allowed a lot of hearsay. It also allowed a lot of conjecture, and it was cumulative. And that's one reason I think it's a problem, because I know that the appellee's brief had responded saying it was, harmless error. But I think that there's an issue with that, which is when you allow 10 statements to come in to confirm something, and then you just have your client come up and say, yeah, that's what happened, it is not reasonable, it is an abuse of discretion at that, I believe, to think that someone can then discount, well, this maybe shouldn't be there, or this should be the heel. And that's where the findings of fact and the CASA report coincide. So I just want to clarify that, because I'm not sure my brief was particularly good on that point, but it is how I see it, that the CASA report should not have come in. It is built specifically for court, and it contained numerous amounts of hearsay.
Did the trial court, in its order, did the trial court reference the CASA report at all?
It doesn't. It references the events from the CASA report.
Does it talk about Ms. Reagan's testimony?
It references what was going on in the juvenile court, which a lot of that came specifically from is in the CASA report. So so the problem is in these cases is you're trying something from like the juvenile court, like in this situation from Anderson County. So you're using their orders, you're coming into Chancery Court here in Knox County, and so there's a issue. So the issue always becomes a little bit of like what happened in juvenile court and how does that affect the termination here in Chancery Court. And in this situation with the CASA report specifically, I would say it's that you're allowing DCS, actually random people can be in CASA reports, therapists, kid statements, parent statements that are from maybe another issue.
All right, make sure I understand. So you're saying that the trial court in its order referenced things that were contained in the CASA report, but not in Ms. Reagan's testimony?
I believe so, yes. Now,
Okay.
I mean, there was a 5-day trial, and I'll be honest, like, I have to, like, I don't have all the transcripts directly in front of me to, like, say this is the spot. But yes, Your Honor, because if you look at, and this goes back to one of the other issues I raised, which is the Ms. Gray issue, which is it's the essence of all of the testimony together. And there are things where you're looking at in the findings of my client's inability to have, say, housing, or my client's, when the court found that he didn't believe that my client had shown that she could take care of the children, manifest inability, which I raised as saying that we have switched the board in because she said she could. The only real spot that we had that there was anything in there was from the CASA report. So the only evidence that I know of that I saw in the transcripts was from the CASA report regarding that. So that's an example of where I believe it could have been used. Now, there's nowhere in there, I believe, where the chancellor said, I'm using the CASA report for this purpose. I'm not implying that. So I just believe that the CASA report should have never been allowed in as a general rule. And I believe I even made that very clear in the rule during the trial. I think I even filed a brief to that effect. As far as to my client, I believe any attempt at board enriching or board in swapping in this situation is absolutely not appropriate. It is a constitutional issue. It's clear and convincing. And there are spots where I do believe my client testified, there was no contravailing evidence, and yet the finding was against it, such as when she said that she didn't need to take medication, and the finding was, well, she said that she should be taking medication, but she doesn't want to. Like, that is not what was said. The finding that she said, the doctor said I can or cannot take medication at my own levels. So I believe that is an example of board and shifting. That's specifically in the, I believe the wanted disregard, but I might have that mistaken. And just finally, I would just like to say that the abandonment issue, I think, is unclear of what the chancellor wanted to make his findings. And I know that none of the council were the findings were never made in open court. They were given, they were delivered to us. So there is no way for us to know what his actual desire on that was. And as such, I think it being unclear and the board being on the plaintiff's side, I would state that there was no abandonment from my client on that. So, I would be so. Thank you.
Okay, you have your time for rebuttal. We'll hear from the appellee.
Good morning, may it please the court. My name is Whitson Smith. I, along with Ms. Carolyn Gillum, represent the appellees, David and Terry Cates, in this matter. The guardian ad litem, Melanie Hogue, is also present, and she joined us in our brief. I'll turn first to the issues raised on appeal by Mr. Nathaniel Johnson. The first being whether the trial court erred in finding that the father failed to manifest a willingness or ability to care for the children. The test in that case is set out by N. Ray Elizabeth Y., which is provided to the court in our brief. The test specifically says that a parent must demonstrate a willingness or ability to care for their child by attempting to overcome obstacles that prevent them from assuming custody or assuming financial responsibility of that child. Turning to the present case, the father's visitation rights were suspended by order of the Anderson County Juvenile Court on March 5th, 2020, due to suspected drug use and manufacture. The only thing that the father stated at trial was that he testified he submitted a hair follicle test to the testing facility. There was no other testimony presented on that issue. And as far as I'm aware, there's no other evidence that the father took any action to comply with the Anderson County Juvenile Court's order.
No testimony. He followed up with the testing facility, or?
Yes, sir. I mean, yes, Your Honor, that's correct. Essentially stating that there was no further questions asking him if he ever followed up with the testing facility. Essentially, my recollection is that he testified that he essentially never heard anything else until he received the petition for termination of his rights, which was filed over a year after the Anderson County order was entered. And essentially, our point raised in our brief is the fact that the father took no additional action to advance going to see his children. Essentially, he just claims, he testified that he filed this hair follicle test and essentially rested on his laurels and didn't take any additional action to move that forward. And, you know, I think we stated in our brief, you know, there's no question that COVID-19 impacted the way, you know, the court system, personal lives, business lives. With that being said, that doesn't relieve the father in this case of taking some sort of action to advance the ability to see his children. The second issue raised by the appellant in his brief is whether the child was willfully abandoned by the father. And essentially, that's the same analysis applies in the prior issue. The court in Re Azalaya E, which is cited in our brief, I believe that was cited by the chancellor in his findings of fact and conclusions of law. The father in that case filed a petition to reinstate visitation with his children and never took any further action. You know, our argument is in the brief is, and I guess the court in Re Azalaya E ruled that that was evidence of willful abandonment because the father in that case didn't take any further steps to advance the petition. In my mind, that's one step further than what the father did in this case. I'm not sure if he filed it pro se or retained counsel to file it, but he took an affirmative step to reinstate visitation with his children, whereas the father here just said he submitted a hair follicle and didn't do anything else. At least there's no proof that he did anything else. So another point raised in our brief is that the trial court found another independent and equal ground for termination as to the father. That's in G9A4, which is slightly different due to a modification in the statute. The appellant's brief doesn't raise any issues with that statutory ground for termination, and we would argue that that alone is sufficient to terminate the father's parental rights in this case. The final issue was that we argue that the brief filed by counsel in this case essentially states that the therapist, Jen Gray, recommended reunification with the child. In our mind, or in my mind, that's a mischaracterization of the testimony. She stated that in certain circumstances, would you recommend reunification with the father? And she further testified that the conduct of the father was appropriate in the family therapy sessions. What I feel that the appellant in this case is ignoring is the fact that the family therapy sessions were cut off by the Anderson County Juvenile Court due to suspected drug use and manufacture. I think that's an important factor for the court to consider. And then otherwise, as far as the best interest factors, the appellant doesn't raise any issues with the court's analysis other than essentially stating it's not supported by clear and convincing evidence. It doesn't go into the court's analysis for any of the individual best interest factors in the court's opinion. So as far as the father, we feel that there's independent grounds for termination of the rights in this case that are supported by clear and convincing evidence, and the appellant has not pointed to any reversible error in that case. And we would ask that the judgment of the trial court be affirmed. Turning to the mother's case, the first issue raised on appeal is the admission of the CASA reports. Trial courts are afforded a wide discretion when it comes to admission of evidence, and trial courts should only be reversed upon a finding of abuse of discretion on appeal. Basically, the appellant cites to two specific cases in support of this conclusion. The first case is Toms versus Toms, and in that case, that concerned the admissibility of a GAL report in a child custody case, which I would argue is completely different from the CASA reports in this case. In Toms, the GAL report was the sole basis for the trial court's determination that the rights were to be terminated. The trial court ultimately did, or the appellate court did rule that the report was inadmissible, but it did state that the court could consider the GAL report in making certain determinations. I would argue that this is a completely different case. There was 5 days of testimony presented in this case, including my clients, the appellants, the mother, the father, the CASA volunteer, as well as Jen Gray, who is the family therapist. There was an abundant amount of evidence for the court to consider outside of the CASA reports. The next case that the appellant cites is LVNV versus Mastaw, which is a debt collection case. It's not even related to termination proceedings. The appellant cited just a general provision from that case that basically goes to the admissibility of records prepared exclusively for litigation. And the appellant didn't cite to any finding of fact or conclusion that specifically relied upon the findings in the CASA report, nor how the findings in the CASA report prejudiced their client. And ultimately, even if
Counsel, I'm sorry, did the trial court reference the CASA report in its judgment?
I believe there was one reference to the CASA report, but I'm not sure exactly where it was, Your Honor. But I believe there was one reference to the CASA report in its conclusion. Your Honor, I have it here, but I can't seem
That's fine.
to locate it.
We'll look at it and see.
I believe there was one reference, Your Honor,
All right.
but it's...
Objections made at trial to the admission of CASA, of the report?
Yes, Your Honor. I was not there at trial, but my understanding was...
Neither were we.
My understanding is that the appellant objected to the admission of the CASA report, and the GAL filed a brief along with the prior counsel for the appellants also filed a brief on that issue. I was not able to locate in the record where the court entered an order, and I don't remember discussing the briefs specifically in the trial transcript.
But it was admitted, the record shows that it was admitted as a trial exhibit.
That's my understanding, Your Honor.
Were contemporary objections made to the testimony of Ms. Reagan?
Frankly, I'm not sure, Your Honor. Mr. Beamer most likely objected to the testimony of Ms. Reagan, but frankly, I don't recall from the trial transcript.
We'll look at that too.
The final issue, or the next issue that the appellant raises in his brief is the qualification of Ms. Jen Gray as an expert in this case. Admission, much like the admission of documentary evidence, admission of expert testimony is generally left to the trial court's discretion. Appellate courts should not overturn a trial court's ruling on the admissibility of evidence unless it's shown that the trial court, again, abused its discretion. The first claim that the appellant makes is that Ms. Gray received her degree from a defunct university. Ms. Gray testified that she received her degree from an accredited university, and the appellant has presented no proof that Ms. Gray's degree was invalid in any way. In further support of the trial court's ruling on Ms. Gray's qualifications, she testified that she'd served as an expert witness over 20 times, and further testified that she had never, a trial court in Tennessee had never declined to qualify her as an expert in any case. The appellant also makes a big deal about her working part-time and having lack of publications. The appellant cited to no case law that supported that, and I was unable to locate any case law that stated working part-time and not having any publications was a disqualification as an expert. I think there's plenty of times where individuals serve as an expert in a case that don't have scholarly publications. I think that's certainly a plus, but I don't think that's a requirement. As far as the issue raised by the appellant on the clarity of the trial court's decision on subsection G9A3, we would agree in this case that the trial court's findings are somewhat ambiguous, and if the court finds that that's the sole ground upon which a termination would be based, then we would ask that the court remand the case on that specific ground for clarity as far as the trial court's finding of fact. But frankly, there's other independent grounds that we feel are appropriate for termination in this case. The first ground being in G9A3 for the mother's failure to manifest a willingness to assume legal and physical custody of the child. Essentially, and I already stated the case from In Re Elizabeth Y, so the court has that test. The mother testified in this case that she'd not been working full-time. And let me back up for a moment. We would agree again with the appellant that we have not been able to find any case law that working part-time per se makes the mother ineligible to care for her children. That being said, the mother testified that she was not working full-time because it was hard and overwhelming. She also testified she wanted to apply for disability. And despite the burden shifting argument from the appellant, we think that based upon this testimony and additional testimony from the mother, we feel that the trial court's finding is supported by clear and convincing evidence as to that factor. The sole argument that the appellant makes in opposition to the termination factor, G9A4, is basically pointing to one specific finding in paragraph 92 of the trial court's findings of fact, and essentially states that the trial court is shifting the burden to her to make, to prove the case, or to, and so the trial court didn't state that the mother was untruthful, as the appellant argues, but it should be noted that the trial court did state that he felt that the appellant's testimony was weak at the trial, and then also weak on issues of cross-examination. So the appellant also raised no other issues as far as the court's best interest analysis. Did not analyze any of the specific factors cited by the trial court. So We would ask, or we feel that there's independent grounds for termination in this case, multiple grounds for termination that are supported by clear and convincing evidence and findings of fact made by the trial court. The appellant has not presented any arguments amounting to reversible error, and we would ask that this court affirm the judgment of the trial court and terminate the parental rights of the appellant. Thank you.
Thank you. Hear from counsel in rebuttal.
Thank you. Thank you, Your Honor. May it please the court. Just very quickly, I would like to state, as regard to the father, there was very little testimony taken in any regard to the father. And I believe that this is a very good example of whose job is it to get the evidence in. It's not the father's job to rebut these allegations. It's the job of the plaintiff to prove the allegations. The father's testimony is very brief, and I don't believe if this, Your Honorable Court, would read those testimony, I think you'll see that some of the questions you were asking, it's just not going to be in there. Most of the testimony was against my client during the course of the trial. Also, the order from Anderson County Juvenile, I think, is slightly different than appellee counsel would state in regard to father. So I would state, I think if you look at the order from the actual adjudicatory order from Anderson County, it is not quite as clear-cut as appellee's counsel would make. Also, there was an issue with father's visitation that was very key during the trial, is the apostrophe S, which was that the therapist did not know which father needed the hair follicle and which one didn't. And there are two fathers, because there was actually two cases, which I know that we've broken it up, but there were two cases at the juvenile. And that was a problem from the therapist's standpoint, because the juvenile court order, which is handwritten from Anderson County, has father apostrophe S, not fathers. So she took it to mean both fathers, and no one knew what the actual, and no counsel at the termination was counsel at the juvenile court. So no one knows what was meant by that court order. Anyway, just as some clarification to that. Other than that, I would just state, shifting the burden is a big deal in this situation because it is a termination of parental rights. So the clear and convincing standard is at play, the constitutionality. So I think that it is very important that we be careful not to shift burdens to parents because of that issue. And so I would be asking this court to obviously dismiss and go back to the trial court if necessary, or whatever this court would deem necessary. Thank you.
Thank you. Thanks to counsel, both sides. We appreciate your briefs and your arguments this morning. I think we may have some carryover, so if you would go ahead and call